Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Law of Torts, we are focusing on general defenses against tortious liability, and in that series, this is my 6th video. In the first video, we have tried to cover briefly all the general defenses available with the defendant, and from there, in the second, third and fourth and fifth video, we have tried to understand one of the general defense in detail with case laws. And in this video, we are going to cover one very important general defense, that is private defense. Here we are understanding private defense. We understand three important essentials to consider something as private defense, and we will discuss at least 4 case laws. And before getting in there are 2 repetitive slides where we will see the list of all the general defenses available, and there is one slide that we have seen in the video number 1 on private defense. First, let us cover those 2 slides in about 30 to 40 seconds and then get into details on private defense. Not taking much of your time, let's get into the first slide. General defenses against tortious liability. We have seen 11 general defenses, that is warranty non-fit injuria, plaintiff the wrongdoer, inevitable accident, act of God, private defense, mistake, necessity, statutory authority, act of the state, parents having parental or quasi-parental authority, and acts causing slight harm. This is a slide that we have already seen when we discussed the first video, where private defense is available as a defense when somebody is doing an act to protect themselves or to protect their property. But there are 3 essentials. There needs to be imminent danger, and the defense is absolutely necessary, and only reasonable force is used. That's in brief, but let's try understand the concept of private defense in detail in my next slide. In this slide, let us try understand the concept of private defense in little detail. The first thing that we all should note here is private defense is not just a defense which is available under tort law only, but also it is a defense which is available under criminal law as well. That is what we are discussing when we discuss Indian Penal Code section 96 to 106. We all know chapter 4 of IPC deals with general exception, which covered between section 76 to 106, and section 96 to 106 focuses completely on private defense. When we say private defense, there are 2 important aspects that we need to observe. Law has given permission to protect one's own person, that is body and life, as well as one's own property. Now, when I say one's own, it is not just limited to that person. We can elaborate it when we are understanding section 97 of IPC. Let me quickly read through section 96 and 97 of IPC, and then let us discuss in little detail. Section 96 of IPC discusses about things done in private defense. And the section says, nothing is an offense which is done in the exercise of the right of private defense. Basically, it says every person has right of private defense, and when someone does something for the purpose of private defense, which is his right, in that case, such act of his will not be considered as an offense. That is what we need to understand from section 96. But by reading section 96, we are not getting full clarity. To get more clarity, we have to read through section 97. Section 97 says right of private defense of the body and of property. Now it elaborates. It discusses that private defense is about the body and of the property of a person, and it says every person has a right subject to the restrictions contained in the section 99. Now, what is section 99? It is about the private defense when something is done by a public servant, and let's not break our head at this moment on that particular section. Let's just try and understand what is the first and second clause which is available under section 97. The clause first says, his own body and the body of any other person against any offense affecting the human body. Now it's very clear. It is not just about one's body. One can protect others' body also as a part of private defense. And secondly, the property, whether movable or immovable, or himself or of any other person, against any act which is an offense failing under the definition of theft, robbery, mischief, or criminal trespass, or which is an attempt to commit theft, robbery, mischief, or criminal trespass. So when we are discussing section 97, we have to observe many aspects. Under property, it is not just about one's own property. It may be of one's property or maybe of another person's property, and such property may be of movable or immovable property. And when can he do private defense or utilize private defense? Only when there is some theft is happening, robbery is happening, mischief is happening, or criminal trespass is happening, or an attempt is made to do theft, robbery, mischief, or criminal trespass. These are the circumstances which are clearly been defined under section 97. I hope that is very clear. Now let's move on to the next very important aspect, that is 3 important essentials when one can use private defense. There needs to be imminent danger or threat. There needs to be absolutely necessary to use private defense, and whatever defense is used, that needs to be of proportional force. Now let us try understand these 3 essential in detail, and that makes the major part of this discussion. The first essential while using private defense is very essential is imminent danger or threat needs to be there. Only when there is imminent threat is available, at that particular time one can use private defense to protect his or somebody else's body or his or somebody else's property. Now such threat, whatever he is facing, should be imminent. There is no chance to escape from that. There is no chance for him to take any person's help, or he cannot reach any authority. Only then, where there is a situation that he has to handle at that very moment, in that case he can use the private defense. I have given 4 examples there. 2 situations where it is okay to use private defense and 2 situations where it is not okay to use private defense. Let us quickly read through them and then the concept will be very clear. 2 okay examples. The first one is A is trying to shoot B by using a gun. B throws a rod and kills A. Now A is having a gun and he is trying to shoot B with that gun. Now B has no time, there is no one to help him, he cannot reach authority, and he gets a rod and immediately throws it at A and A dies. Now that is okay because gun can kill someone immediately and that's a great danger. Likewise, B is trying to rape F. F kills B in an attempt to escape. Now if there is no one to protect F from getting raped, she can use the right of private defense and kill B. That is okay. What is not okay? X thinks that Y might kill him someday. So X kills Y. Now X thinks that Y might come and kill him one day, and for that, as a prevention, if he kills Y, that is not private defense. He has time, he can report to authority and he can safeguard himself. There was opportunity, but instead doing that, he is killing Y. In that case, that becomes murder. So that is not okay. Likewise, Y threatens that he will kill X someday. To avoid his death, X kills Y. Now this is also not okay. If somebody is coming and threatening you that they will kill you, to avoid your death, if you are killing them, then that becomes murder. Only when they are in front of you and they are saying that they are killing you right now and they have some dangerous weapon in their hand, you have no chance to escape, you have no one to help you, you cannot reach any authority. In that case, as a part of private defense, if you are killing the person who is in front of you, that is fine. But then that's not the end of it. We have to discuss about how much proportion of force that we can use. That also I am discussing in later stage. But if you are seeing your death, there is no other chance available other than killing the person who is in front of you, then as a part of private defense, killing other person is okay. Now let's move on to the second essential. I hope this is very clear, imminent danger or threat. With that assumption, I am taking you to the next slide. The second essential is such private defense act is absolutely necessary. Now necessity knows no law, that is the legal maxim. We will discuss in detail on the concept of necessity when we are discussing necessity as a defense. But here remember, when such act as a part of private defense is absolutely necessary, that is being taken care by law, law gives exemption, but if it is not so, in that case law doesn't protect you. The beautiful case law that we need to understand here is the Queen versus Dudley. Now here what happens, three people were traveling in a boat and they get nothing to eat. Two of them decides that there is a small boy, we'll kill him and eat. Now why are they killing the boy? Because they are hungry and they want to eat something. So by killing one boy, they can protect themselves. Now why did they kill this boy? To protect themselves. But the court didn't give this exemption under private defense because there was no threat to them from the boy. Yes, he would have died by hunger. That is a different story. But saying that you are dying by hunger, you don't have the right to kill someone. That's not private defense. If the boy has threatened them that he is going to kill them, and as an act of protecting their life if they had killed boy, that is a different story. And they need not to kill the boy because they are two people, they can still protect themselves without killing the boy also. That's another angle. But now when they two are attacking this boy to kill, if the boy is killing both of them to protect himself, that is an act of private defense. But here, just to suffice their hunger, they killed the boy, and the court said this is not an act of private defense. That is a very important act that we need to remember. Likewise, if somebody is trying to avoid their hungry, and for that if they are stealing the bread of another shop, now that is again not justiciable because they have no threat from anyone else. They are trying to do something to suffice their requirement, and in that attempt they are committing what? They are stealing it, so that is theft. So in that case, that will not be considered as an act of private defense, though you are trying to safeguard your life by stealing and having that bread. The private defense can be used only when there is threat from someone else. Okay, only then you can use it, only then it becomes necessary. Otherwise it is not necessary, and only when such necessary arises to use your force and protect yourself from some other person, to protect your body or protect someone's body who is belonging to you, or someone's property or your own property which may be movable or immovable property, whatever. So we have discussed all of that. In that case only it becomes necessary and you can use private defense. And there I told about force, how much force, which is what we are going to understand in the third essential. What is the third essential? The force that is being used in the process of private defense need to be proportional or as much as required only. One cannot use unnecessarily additional force in the name of private defense. Again, I have given here two examples for both okay and not okay. Here there is no scientific calculation available as to how much force can be used. It completely depends on the scenario. So the cases will be decided based on each scenario, and for that particular case how it looks like. That is how the courts are going to decide. Now let's look at two okay scenarios and two not okay scenarios. The first scenario says A tries to kill B by a rod. B shoots to A leg and injures him and ties him with rope, calls for help. Now A has rod and B has a gun. A is trying to kill B with the help of rod, and what does B do? B shoots at A's leg, which is not causing any death of that person because he is just shooting to leg only, and after shooting he immediately ties A and calls people for help. That way he is protecting A also, and he is saving himself from the attack of A. That is okay. The second example, a strong well-built person tries to attack B, and B, to protect himself, starts hitting with a stick, which is not as much as risky of causing death. Now A is a well-built person, he is trying to attack B, and B is not that strong. So what does he do? He takes the help of a stick and protects himself, and he is not causing the death of A also. That way this is proportional force, which is okay. What are not okay? A is trying to commit theft, B kills him with a sword or gun. Now somebody has come to your house to commit theft. Need not to kill them. You can still hold them, tie them, all of that you can do. Call for help, all of that you can do. Killing them with the help of sword or gun is necessarily not required. It becomes out of proportion, so that is not okay. Likewise, a very weak person is trying to hit 5 people and these 5 people together kills A. That is not required, because the person who is trying to hit 5 people, he is already weak. You can still give one slap and send him, or you can tie him, or you can give to police. You can do whatever you want to, but not to kill him, because that becomes out of proportion, which is not okay. With that, I am taking you to 3 important case laws in my next slide, and that also concludes our discussion. Here we have 3 important case laws, and all of them are related to protection of property or self-defense against your property. Now, to protect your property, law allows you to put glass pieces on the wall, or you can have a fierce dog, or you can put spring gun. All of that is available under law itself. But when you are doing that, you have to put notice. That is very important. These 2 case laws, the first 2, Elliott versus Wikes and Bird versus Holbrook, we have already discussed in our earlier presentations also. And here also we'll discuss those 2 case laws along with Ramanuja Mudali versus Mr. Gangan. In the first case, that is Elliott versus Wikes, there was notice available, but then the plaintiff took risk of doing trespass and he got injured. And the court said, as the person who has did trespass was aware that spring gun was available there is no liability on the defendant. That's why there is no compensation available to the plaintiff. But in the case of Bird versus Holbrook, what happened? There was spring gun to protect his property, but the defendant has not put any notice, and the plaintiff was an innocent trespasser, and as he was not aware and there was no notice, the defendant had to pay compensation, not because he has set up spring gun in his property, but because there was no notice available. Now, this notice part plays very important role. In Elliott versus Wikes, what happened? The defendant has put notice, or the plaintiff was aware. Whereas in the second case, the plaintiff was not aware and defendant has not put notice. That is the difference we need to observe. When there is notice, there is no compensation available to the trespasser. But if there was no notice, in that case, the defendant loses the case. That is what we need to understand. And the third case law, what is that? Ramanuja Mudali versus Gangan. What happened here? Nothing much. This is the copy paste of the case law Bird versus Holbrook. Here also the facts are same. The defendant was crossing the land of the plaintiff to reach his home, and he was not aware that there are some electric wires available to protect the land of plaintiff, and there was no notice available, and the defendant got injured, and the court said as there was no notice available, plaintiff is liable to pay compensation to the defendant. I hope that is very clear. So, in a nutshell, all that you need to remember here is, when we are discussing about private defense, it is not just under tort law, it is under IPC also a defense to the defendant. And we have to mention IPC section 96 and 97 possibly, discuss the 3 important essential, that is imminent threat is available and the force is absolutely necessary or it is required, and there needs to be proportional force used. And then there are 3 case laws which I have discussed here. There mention about the requirement of the notice, and that completes your answer on the private defense part. I hope that is very clear. With that thinking, I am handing over this presentation to Nishan.
Prayer is one of the most important part of our life. But remember, if you don't put sufficient effort, then God won't give good results. With that, I am concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.